I'm Kate Fort. I am a professor at Michigan State University College of Law. I run our Indian law program, I run our Indian law clinic. We have an Indigenous Law and Policy Center, and I also, through the support of KC Family Programs, run what we call the ICWA Appellate Project, which provides technical assistance, research, and brief drafting to tribes who find themselves involved in appeals, usually in state courts, though as you will see, my life changed a lot recently. Chrissi very kindly gave a plug for our Turtle Talk blog, which I forgot to do last time. It's turtletalk.wordpress.com. All of the cases that I talk about, the information I talk about is all available on there. We put documents up there from PACER for free to people to get. It's a big... Chrissi said to sign up for the emails. I need you to know that we post about 5 to 10 posts a day, and you shouldn't sign up for our emails because you will get a lot of them. You can get a digest version. I would do that. So before I get started, how many of you have any, I talk about the Indian Child Welfare Act in this. How many people know what the Indian Child Welfare Act is? Great. Okay, state court practitioners? No, federal court. Okay, good. No, this is who I want to talk to. But I'm sorry, so we're going to start it. I would like to also say, I just want to apologize because I'm using a timeline because I wasn't sure entirely who my audience would be, and so it's not as exciting as some of my other presentations, but I'll try to keep you engaged. You should know that what I cover in the next 20 minutes, I spend an entire semester teaching law students. So in 1978, the Indian Child Welfare Act was passed by Congress to address the wholesale removal of Indian children from their families, primarily through state and federal actions, initially through boarding school policy by the federal government, and then through child welfare removal policies by state governments. It's a remedial law. It is a federal law that state courts have to apply in their courtrooms to address these issues of child welfare issues for Indian kids. I promise I had it more together when I wasn't on videotape and gave this same presentation an hour ago. Child welfare proceedings, the Child Welfare Act applies very specifically, and it's important to know when it applies and what it applies to. So the first thing you have to have, if you're a state court in a child welfare proceeding, you have to have an Indian child. An Indian child is defined in the Act. It's defined as a member, the child is defined as a member of a tribe, that's the easy one, or is eligible for membership and is a biological child of a member. If you have one of those two things, you have an Indian child, and then you can move to the next question, which is, do you have a child welfare proceeding? Also defined in the Act. So, a foster care placement, a termination of parental rights, a pre-adoptive proceeding, or an adoptive proceeding are considered child welfare proceedings under the Act. If you have both of those things together, you have an ICWA case. In many states, it includes a guardianship. It includes, especially if it's an involuntary guardianship. What courts consider particularly is whether the parent can get their child back upon demand, right? Can the parent go and get their child? No? Okay, you have a child custody, you have a child welfare proceeding. It doesn't apply to child custody proceedings as a result of a divorce, and it doesn't apply, it does apply if you have a step-parent adoption. That's getting into state court weeds, and we don't need to go there right now, because I want to talk to you about why I think it's important you know about ICWA. In 1982, the Oklahoma ICWA passed. Something that a lot of people don't know is that many states have their own state ICWA laws. There are now 8 comprehensive state ICWA laws. By that I mean a state has incorporated all of the protections and provisions of ICWA into their state code as specific to their state. So when we did ours, our Michigan Indian Family Preservation Act, what we did was incorporate a lot of our case precedent into our state law. And so ours is specific to Michigan. We spent a lot of time meeting with tribes and other stakeholders to determine what would that law look like and what would it do. For the record, I was a big skeptic of state ICWA laws for a long time. I'm like, it's federal law. Apply it. Like, it doesn't seem like it's that hard. It is that hard, apparently. So what we did was, but then Michigan got theirs and we passed it, and it has meant an increase in funding and training for judges. It's meant that judges have paid more attention to the law because it's a state law. It's meant that our In Michigan, they graduate us so smart that we don't have continuing legal education credit requirements ever. So I can't get people to get trained on stuff, but it has meant that we have some more trainings because it was a new state law, and so it's been really incredibly useful to us in state court. Since I'm in Kansas, I have to talk about Baby Boy L, which was a case back in 1982 that said basically that first provision, do you have an Indian child? Which, by the way, if you have an Indian child, the only way you know if you have an Indian child is if the tribe tells you you have an Indian child, right? So one of the very first provisions of ICWA is if a parent comes in from the state court and says, and it's a child welfare proceeding, and says, yep, I'm Indian, I'm Native, I'm Choctaw, I'm Anishinaabe, I'm any of these, right? The court has to tell that tribe they have one of their kids. That's we call that notice. You have to tell the tribe. The tribe is the only one who can tell back, yep, that's one of our kids. There are 567 federally recognized tribes. All of those tribes determine their citizenry and their membership internally through constitutions and codes. Because you know that one tribe has one way of defining their citizenry does not mean you know how the next tribe defines that citizenry. In my state alone, we have 12 federally recognized tribes. All of them have different citizenship requirements for their tribes. So if you have ICWA and it applies, there are a whole bunch of provisions that go with that. You have a couple of things that can happen. So the tribe gets notice, they say, yep, Indian child, yep, child custody proceeding. The couple things can happen. You have to make sure you have the right jurisdiction. Does the child live on the reservation and somehow got into state court? If that's the case, the tribe has exclusive jurisdiction, and that case has to go back to tribal court. If the child lives off the reservation, the tribe and the state have concurrent jurisdiction over that child welfare proceeding, though presumptively tribal, which means the law says the court shall transfer the case back to tribal court absent good cause to the contrary. As I noted, we do a lot of litigation. Good cause to the contrary is always an area of litigation anytime you hear that. So in the congressional record, it seems fairly clear in this case that what Congress meant was an inconvenient forum analysis. Is it inconvenient to transfer that case back to tribal court? A case has been in the news lately. The little girl was in California. She's a Choctaw citizen. Choctaw Nation got notice, intervened, and said, well, we're not transferring this case to tribal court. It doesn't make sense. Her family's in Southern California. Her extended family's in Utah. We're in Oklahoma. We're going to pay attention to this case in state court, but we're not transferring it, right? If the case stays in state court, the provisions of ICWA apply regardless of whether the tribe chooses to intervene. They have an intervention of right or not. It's a remedial statute. It's to improve the treatment of state courts toward Indian children. So these provisions that are required under the law include the placement preferences, which is to say children should be placed with their family, their extended family, their tribe, or their community. It includes higher standards of evidence in the child welfare arena than is normally required under state law. Clear and convincing standards to do a foster care placement, beyond a reasonable doubt standard for a termination of parental rights. It includes a requirement that you have to have the testimony of a qualified expert witness to say, yeah, this kid should not be with their parents. That qualified expert witness is someone who has to know the tribe, has to be familiar with the tribal child raising traditions and customs of that tribe. In addition, and one of the most important pieces from the perspective of why we have ICWA is the right of parents to have what we call active efforts to keep that family together. Federal law, which has been incorporated into state law because of the funding mechanism attached to it, says you have to have reasonable efforts, right? State court judges have to make a finding that reasonable efforts were made for this family in order to get their Title IV funding for foster care. Under ICWA, you have to have active efforts. It has to be more than. We used to litigate and just be like, did you do more than reasonable efforts? Great. Probably active efforts. Let's take a look. The federal regulations, which just passed, which I'll talk about, in a few minutes, now define active efforts, or at least give 10 or 11 elements of what can be considered an active effort that you've done for that family before you place a child in foster care or terminate parental rights. So sorry, I got ahead of myself. The existing Indian family exception in Kansas said, hey, state court judges, we are deciding whether that child is Indian enough for the law to apply. Is there an Indian family that this child's being taken out of? And we're going to decide that, not the tribe. That's basically the existing Indian family exception. We have been litigating and fighting this, thanks Kansas, since 1982 to say no, the law means what it says, the language of the law means what it says. And relatively recently, it's been pretty clear that this exception is going out of favor, including in Kansas, where in 2009, they explicitly overturned in Ray Baby Boy L and said, no, that actually doesn't make any sense if the statute says what it says. So these are other state ICWAs. The Nebraska 2015 ICWA law is fantastic. It's a really good law. It's thoughtful. They spent a lot of time on it. There have been some good Nebraska Supreme Court decisions coming down interpreting it, which is why I highlight it somewhat nearby. The U.S. Supreme Court has interpreted ICWA twice, and the first time was in this case. In both cases, those two decisions involved voluntary adoptions. A lot of times when you hear about an ICWA case, it involves a voluntary adoption because it causes a lot, it's a very difficult area of law, right? There's a lot of interests. In 1982, this case talks about domicile. This case says, no, domicile, Indian parent's domicile determines jurisdiction. If an Indian child is with the parent, the Indian child has that parent's domicile. In this case, you had a mom who left the reservation to give birth and then put the child up for adoption, and they said, that means the mom's domicile wasn't the reservation, even though she moved back to, right? She had not changed her domicile. Those babies had, she had twins, those babies had the mom's domicile, and the tribe had exclusive jurisdiction over that case. This is the NRA AJS out of Kansas, which pointed to a number of state ICWA laws, including Washington's, which we just a few months ago won a big case in the Washington Supreme Court saying, yep, that's right, no existing Indian family doctrine. We said it in our state law, and now we're saying it explicitly in our Supreme Court. And then Wisconsin's ICWA also was passed. It's like 13 minutes. Okay, the reason why I want to talk to federal practitioners about these cases. There are a lot of federal lawsuits right now involving the Indian Child Welfare Act and child welfare in this area. This first one, this March Oglala Sioux versus Van Hunnick, was filed back in 2013 in the South Dakota, District of South Dakota. It involves issues surrounding the due process rights and ICWA violations towards Indian parents in emergency hearings. So when a kid is first removed, how long is that emergency hearing? What are the due process rights of those parents? What does the state have to do? And the federal district court in that case said, yeah, these are pretty big violations of these parents' due process rights. 60-second hearings, no opportunity to hear why the kids have been removed, no opportunity to counter why the kids have been removed, like really fundamental due process violations. In June, that's a Supreme Court case, adoptive couple versus baby girl, which I'm not really going to get into other than to say it did not overturn ICWA, which is what I get a lot, and it did not adopt the existing Indian family exception, which I just mentioned earlier. It did involve basically the fact pattern of when one parent, when a mom puts a child up for adoption and a dad says, no, I don't want that to happen. What happens? What happens in the end there, and what happens under ICWA? And we got the Michigan Indian Family Preservation. There's a law review article out where I say the Michigan Indian Family Preservation Act will never pass. Our legislature, it did. You can do a lot of things in lame duck, and this is one of them. So in 2014, the feds decided to get super involved in ICWA stuff. And they sent out a letter, and they said, what can we do to help states and tribes on ICWA matters? And a bunch of people replied and said, hey, you haven't issued new guidelines since 1979. It'd be super if you did something that was more up to date than 1979. They were like, okay. And some of the comments in response also said, hey, could you please do federal regulations? Because we'd like something that's a little tougher than just guidelines. Because what happens with guidelines is state court uses them if they agree with them, and they don't, and then they say, well, they're not binding if they want to come to a different finding, right? And so we were like, well, maybe if we had regulations, that might help. And then 2015 happened. And we got the revised guidelines, and then we got a lot of federal lawsuits all at once. So NCFA versus Jewell attacked the constitutionality of the revised BIA guidelines. That has since they appealed, the court at the lower, the district court said they're not binding, they don't have to go through the APA procedures, and they're constitutional. Just like a couple days ago, we actually got an order. They appealed that to the Fourth Circuit, and since the 2015 revised guidelines have now been withdrawn and replaced with the 2016 guidelines, it was vacated. It's moot and vacated. So we don't have to deal with that one anymore as of 2 days ago. Doe versus Jessen and also Doe versus Pruitt actually both address state ICWA laws. And the provisions on both of them are the question of whether the state ICWA law that says, yep, tribes need to have notice and they have a right of intervention in voluntary adoptions, is that constitutional? Doe versus Jessen, they just are briefing right now, dueling motions for summary judgment. Doe versus Pruitt, tribe filed a motion to dismiss, as did the state, and we're still waiting on a decision in that case. Carter versus Washburn is a proposed class action lawsuit saying all of ICWA is unconstitutional. It's been brief, nothing has happened of note since July of 2015. And then Don versus Nelson, which is the Western District of Michigan and had to do with jurisdictional questions about whether the state or the tribe has jurisdiction. Something I should note in the transfer, the jurisdiction, who has jurisdiction, there are two vetoes to that. One is the tribe. A tribe can say, no, we don't want jurisdiction. And the other is the parent. No parent can be taken into tribal court if that's not where they want to go. They have a right of veto. So, unless they live on the reservation and then they live on, that's their choice. But we've been noting more and more cases where they're going really fast to federal court. Especially here, we have Watso v. Jacobson, another Minnesota one, and Renteria versus Shingle Spring Band, both went up really fast involving jurisdiction questions. Who has jurisdiction to make decisions over Indian kids? In June, we got federal regulations, and they are in effect, and we expect them, we expected a lawsuit much quicker, like we expected another federal lawsuit and don't have one, so we don't think we're gonna get one. We also are pretty sure it's gonna survive. We don't think Congress cares enough to pass a congressional resolution of disapproval for these regulations is where we're at right now. But the thing that I wanted to really note that's important for me, for federal practitioners is, like this was a 20-minute like this, right? And now this is all I do. I teach students, I recruit students to law school, and I do Indian child welfare. When we go into federal court practitioners, for all sorts of reasons that make lots of sense, don't do child welfare, right? Like that's a state, that happens in the states. When my friends who are federal prosecutors see cases involving kids, they're the worst cases, right? They're bad cases. Trying to explain to federal court practitioners that child welfare is generally a result of systemic poverty, mental health issues, and chemical dependencies of the parents, and that the purpose, that the burden on state courts is trying to address all of these fundamental systemic failures to make families safe and healthy for kids. That's what we're working on. And so from a perspective of child welfare, what ICWA does is keep the placement preferences. The point is to keep the kids with their family and their community. So when they're put in foster care, they're not torn away from their siblings and their school district and anybody they know. Active efforts is to get additional services for a family that needs them. That's the point of why we ask for them. So when we go up to federal court and federal judges read the brief on one side going through all the facts of a case that are no good, right? Like, because child welfare cases are hard and they're misery. And I have people come up to me all the time and go, I can't believe you do, how do you do this for a living? I'm like, how do you not? You got to do it. What am I going to do? Not look out for kids and families? So that's what I do. But it's still really hard to explain to, we're in a different system when we're talking about child welfare. And when we go up on some of these cases, I always want to make sure that we have a sort of a fundamental base level understanding of what does your state's child welfare system look like on a daily basis. And if you don't know, you should know. Like, you should take a look at it. And I think most people would be, frankly, shocked and appalled at the lack of resources we devote to child welfare in our state systems. So, ICWA in 20 minutes, and super not depressing. So, thank you very much for coming to listen to us. We appreciate it.
My name is Chrissi Nimmo, and part of introducing myself, one of the things in Indian Child Welfare Act cases that we deal with often is bias. Bias against the tribe, bias against Indian people in general. And I'm going to cover three kind of issues / cases today that are a little bit controversial, and there's some political commentary there. So in fairness, I want to share my bias. I'm a tribal citizen. I have been employed by a tribe for 8 years. We're the Attorney General's Office of the Cherokee Nation, and we do in-house counsel duties as well as prosecution. Adoptive couple v. Baby Girl, which also is called Baby Veronica, was my case that went to the Supreme Court. So I have a passion for Indian law. I'm a Democrat. I tend to be left of the line, so some of the issues we're going to talk about are very political, and I just want to be fair about who I am and what I am. I'm the mother of Indian children. I have 2-year-old twins who are citizens of the Cherokee Nation. I have a third child on the way, so Indian child welfare issues and children's issues are very important to me and important to what I do. So just in the sense of fairness, I want you to know a little bit about who I am, because we're going to talk about some issues. Something that is been a really big deal to the country in the last month, but to Indian country is the new president and the new administration. So much of what affects Indian people is federal law and federal agencies and who are in charge of those federal agencies and the decisions that federal lawmakers make. Kate talked about ICWA, and it is a federal law that is litigated almost exclusively in state court, with a handful of the cases that she talked about. Most other federal Indian laws are litigated in federal courts. So federal court judges and elected politicians and lawmakers are very, very important to Indian country. And as tribes have kind of expanded their economic footprint, you've seen a lot more influence from tribes into the political arena. Tribes, like other entities and other organizations, have lobbyists and spend lots of money on attorneys and people in DC to talk to lawmakers to bring a tribal perspective to that. So our new president, we don't know what he's going to do with Indian law, but within his first week of office, he signed an executive order addressing the Dakota Access Pipeline, which I'm going to talk about in some depth. His past with tribes is not good. I've got a little clip I'm going to show you a little bit later in my presentation. Something that's interesting, we all learned last night that we got a new Supreme Court nominee, Neil Gorsuch, which is a 10th Circuit Court of Appeals judge. So I know that Kansas is in the 10th Circuit along with Oklahoma, and the 10th Circuit does a lot of Indian law. And they do pretty good. It's one of the best federal appeals courts for decisions favoring tribal interest. And because we're talking about Indian law today, I'm only talking about from an Indian law perspective. Judge Gorsuch, from an Indian law perspective, has a really good record. He has a strong record on siding with tribal interest in Indian law cases. So you're probably going to see some support for his nomination from Indian country. One of the interesting things about politics is that where people stand on Indian issues don't necessarily follow a traditional conservative liberal split. And the example is in the adoptive couple case, which we lost 5-4, the 4 justices in the minority were the 3 women who are considered liberal and Justice Scalia. So it made a very interesting split on the Supreme Court in this Indian law case, and you will often see that. One of the cases I'm going to talk about was a 4-4 split. Indian law cases a lot of times are not unanimous decisions, and you have really polar opposite dissenting opinions. But there's a lot, every year the U.S. Supreme Court hears a couple of Indian law cases at least, and again, it's something that is heavily litigated in federal courts because most of it is federal law, and in fact, states can't pass state laws that directly impact on Indians unless they've been given that ability by Congress. So that's kind of the background. We weren't given any direction for this today. We were invited by Professor Cronk at KU to come talk about Indian law because they're doing this great expansive conference about all areas of the law, and she's like, we need Indian law, and Chrissy and Kate, we want you guys to come talk about it. So we were kind of left to pick what we wanted to talk about. I usually also do ICWA stuff, so I decided to kind of pick 3 current events or current cases to just kind of do an overview of where Indian law currently stands. So the first thing I picked was the Dakota Access Pipeline because it's something that got a lot of attention. Usually these types of issues don't get a lot of attention. The only people that know about them are people that care about Indian law issues. But this was because of the protest at the Standing Rock Sioux Reservation, because of some of the celebrities that got involved in this. We've had actors and singers at big award shows say that they were standing with Standing Rock, and celebrities on their social media pages tweeting hashtag no dapple, hashtag standing with Standing Rock. It finally made some really mainstream media coverage kind of when the clash of the protest came. So it's interesting from the perspective of a tribal citizen and an Indian law practitioner, the things that don't get attention versus the things that do. But this is something that was in the media. So I just wanted to do kind of a quick overview. And again, this is partially why I wanted to tell you where I'm coming from, because there are a lot of people on both sides of this issue. And if you go to a page sponsored by the pipeline industry, you're going to hear very different facts from the alternative facts from the ones I'm sharing with you today. And, some of them we can agree on, some of them we disagree on. But these are kind of the players involved in this. And the reason I put the worth of these companies, we're talking about really, really big money. And if this pipeline does not get completed, there are a lot of people going to lose a lot of money. There are also people who aren't going to be able to get oil as cheaply as they want to. So it's a big deal, and I understand both sides of that. So the opposition that originally started with the tribe, and the tribe has been outspoken against this pipeline since it was planned. They went to public meetings and they voiced their concern. But then, like I said, you got some celebrity involvement. This become kind of an environmental issue that was bigger than the tribal issue. And then you also have people, simply farmers, who are, opposed to taking of their land through eminent domain, who have been outspoken against this too, because this is the scope of this project. Estimated cost of $3.7 billion, which that is unquestionably gone up because it was supposed to be completed by January 1st, 2017, and it is not. Because there's a stretch in North Dakota that hasn't gone under a lake it was supposed to go under. It's 1,100 miles long, a 30-inch diameter pipe. It is completely underground, runs from North Dakota to Illinois, and if completed, will transport a potential 570,000 barrels of crude oil a day. This is a map that I had to include because this is kind of the thing that gets Indians riled up the most. So what you see in this picture, and you will see by how it's captioned, the black snake in Sioux country, who made this map. But what you will see in this picture, the dotted line is the original proposed path of the Dakota Access Pipeline. It goes north of Bismarck, North Dakota. It was rerouted. There's lots of explanation of why it was rerouted. What I will tell you that Indian people say, it's because it was originally going to go close to an all-white community, and now it's going close to an all-Indian community. The area in the light gray is not officially Indian country. This is one of the issues that is still being litigated, still in court. The Sioux say that this is Indian land because there's no question that it used to be Indian land. It was ceded through a treaty, but the Sioux refused to take the money, and they have always refused to take the money. So they said, we never took the money for this land. It's still ours. We still have a right to it. If we consider that not treaty land, which the U.S. government is and Dakota Access Pipeline is, the pipeline does not cross Indian country. It crosses directly north of the reservation. But what we have is the pipeline is 90+% complete, and it goes up to either side of the lake. And December of last year, the Army Corps said that it was not granting the easement that the pipeline would have to drill under the lake and lay the pipeline. They had done through the process an environmental impact assessment, and the Army Corps said, no, we're requiring a full environmental impact statement. If anyone does environmental law, that is a much more involved process. You have to do much more consultation, the study of possible environmental impact, alternative routes, all of these things have to be considered. So they published that on January 18th, just a few days before President Trump was sworn into office. It's open for public comment. And as I said, one of the first executive orders from President Trump was basically complete this pipeline. This is something that is developing as we speak. Yesterday, a senator and a representative from North Dakota said that they were informed by the Army Secretary that the Army Corps was going to grant the easement and they would be notifying people very quickly. Today, I didn't even get to update my PowerPoint. Today, the Army Corps came out in a filing in one of the pending federal court cases saying, no, we're not granting the easement. We are trying to comply with both the process of the assessment as well as the executive order, and we will basically let you know something when we know something, Judge. So this is a very, very ongoing, evolving. We saw on social media today that there was a new camp that was on private property, and police were going in to break up the camp because they were trespassing on private property. So this is the executive order, some of the quotes from President Trump, that he ordered that the Army Corps review and approve in an expedited manner to the extent permitted by law as warranted what is necessary to complete the pipeline. And, quote, I believe that construction and operation of the lawfully permitted pipeline infrastructure serve the national interest. So I just got a couple of pictures here to talk about kind of what this really is and is not, and the reason why this has been a big deal, especially in Indian country. So I actually don't know that this is North Dakota, but this is the Dakota Access Pipeline. And this is just to show you that even though this is underground and eventually this will all be covered up, it's a pretty big footprint, an environmental footprint. And part of the Standing Rock Sioux's opposition to this pipeline, other than it crossing the lake and having potential impact on the water supply if there's a leak, that it goes across what was traditional ancestral land of the Sioux, and that there are cultural and historical artifacts there, that there are bodies buried there, that there are, and that by digging up all this and laying this pipeline, you're going to disturb that. Now, I will say, as part of the environmental statement and the assessment, that type of stuff is looked at. There are tribes have officers, the EPA has people, the companies themselves hire private individuals to kind of do this assessment of, will we actually impact cultural and historical sites? The Dakota Access Pipeline says no, the tribe says absolutely yes, you will. These are just some pictures of the protest. Kind of wintertime is when this really got attention, and it was just pretty impressive to see the top left picture. That is a day that a lot of veterans came to protest at the camp, and it was literally a blizzard that day. North Dakota in the wintertime is not a pleasant place to be, and there were thousands of people out protesting. So these are just some of the pictures, and they're impressive photos. This was the first baby who was born at the camp. I think there were a couple others since then, but this was the first one, and that kind of got a big splash of media attention. This is the law enforcement response, and the reason I have law enforcement in quotes, there are two pictures in the top left, bottom right corners involving dogs. This was not law enforcement. These folks were private security guards hired by the pipeline company to keep protesters from being on pipeline land. And there's video out there that is very, very graphic of the day that there was kind of this clash, and they released these dogs into crowds of people. And these were private security guards. This wasn't law enforcement. No one was being under arrest. The other top left was a night that it was, I think, below 20 degrees outside, and they were spraying water cannons on the protesters. And the bottom right photo is a group of protesters who were in the river, and they were not advancing onto the riverbank. They were simply standing in the river, and they were sprayed with mace or pepper spray out of big, huge, fire extinguisher type. And these are some of the images that started getting this into the media, because it really was, with the exception of kind of a few incidents, very, very peaceful protests, and we saw these protesters being treated in a way that people weren't comfortable with. So I'm going to switch gears here and talk really quickly about tribal sovereignty / jurisdiction. But I have a couple of clips to play just because I'll explain to you why. But here is the first one. This is former President George W. Bush. Has anyone seen this clip? You have.
My name is Mark Trahant. I'm the editorial page editor of the Seattle Post-Intelligencer and a member of the Native American Journalists Association. Most school kids learn about government in the context of city, county, state, and federal. And of course, tribal governments are not part of that at all. Mr. President, you've been a governor and a president, so you have a unique experience looking at it from two directions. What do you think tribal sovereignty means in the 21st century, and how do we resolve conflicts between tribes and the federal and state governments?
Yeah. Tribal sovereignty means that it's sovereign. I mean, you've been given sovereignty, and you're viewed as a sovereign entity. Okay. And therefore, the relationship between the federal government and tribes is one between sovereign entities.
So that's what tribes used to have to deal with, as far as the President of the United States and their knowledge of tribes. And I can tell you, I've used that clip for a long time. It's been around a long time. And as someone who does nothing but Indian law, it's just shocking to see the President of the United States. There's a long, long history of Indian law and interaction with tribes in this country, obviously, since the day that it was founded. So that one I've used for a long time just because it's kind of funny. And, and now looking at that, it's like, that wasn't so bad. Because now we have a president who, he does know a little bit about tribes. What he knows is that they're allowed to have casinos, and he doesn't like it. So this is also an old clip that wasn't relevant until recently.
Is this you discussing Indian blood? We're going to judge people by whether they have Indian blood, whether they're qualified to run a gaming casino or not?
That probably is me, absolutely. Because I'll tell you what, if you look at some of the reservations that you've approved, you, sir, in your great wisdom have approved, I will tell you right now, they don't look like Indians to me, and they don't look like the Indians. Now, maybe we say politically correct or not politically correct. They don't look like Indians to me, and they don't look like Indians to Indians, and a lot of people are laughing at it, and you're telling how tough it is, how rough it is to get approved. Well, you go up to Connecticut, and you look. Now, they don't look like Indians to me, sir.
Thank God that's not the test of whether or not people have rights in this country or not, whether or not they pass your look test.
Depends whether or not you're approving it, sir.
No, it's not a question whether I'm approving it. It's not a question whether I'm approving it. Mr. Trump, you know in the history of this country where we've heard this discussion before, they don't look Jewish to me.
Oh, really?
They don't look Indian to me. They don't look Italian to me.
Mm-hmm.
And that was a test for whether people could go into business or not go into business, whether they could get a bank loan. You're too black, you're not black enough.
So when the candidate, Donald Trump, appeared on the circuit for the Republican Party, it's understandable that tribes were immediately concerned. When he won the nomination, tribes probably more concerned, and when he was elected president, tribes were just didn't know what to do, because his history with tribes was this, arguing against federal recognition of a tribe. And actually, if you see the background of this, it's even more offensive, because he's not talking about Indians that look like me. He's not talking about blonde-haired, blue-eyed Cherokees. He's actually talking about a reservation that has, or a tribe that has a lot of citizens that are mixed African-American blood. And what he says in some of this background information is that they're black, they're not Indian. And that he should get to decide who gets to be a member of a federally recognized tribe based on whether or not they look like what he thinks an Indian should look like. So that's the background that tribes have going forward with the new president and the new administration. So you understand why there is concern with the people that he appoints to different agencies, and their control basically that they will have over tribes. So much of what tribes, their interaction with the federal government is through the Bureau of Indian Affairs, the Department of Interior, Health. Indian Health Services are funded by the federal government because of treaty rights. So there are all these issues that are very, very important. And so tribes are kind of in a state of panic right now. And I want to talk just really briefly. And the reason I show you these, I say it's tribal sovereignty. And I'm going to talk about tribal jurisdiction. And what we talk about when we talk about jurisdiction and sovereignty, kind of the two big areas are who can the tribe sue? Who can a tribe exercise jurisdiction over? And not just sue. Who can we pass regulation over? Who can we bring into criminal court? Who can we make pay taxes? Who can we say can and can't come on our land? Can we stop a pipeline from crossing our land? So those are issues of kind of who the tribe can control. The other issue of sovereignty is if you are sovereign, as President Bush said, that's what it means, you're sovereign. What it really means, one of the big things that it means, is that you can't be sued without your consent. The federal government, the state government, and tribal governments, the basic rule is, unless you say so, no one can sue you. And all three of those types of governments have passed certain laws that said in these situations you can sue us. Kind of the basic, the bedrock of tribal sovereignty is tribes are immune to suit absent an explicit waiver of tribal sovereign immunity or some law by Congress that says, yes, you can sue the tribe. And that is true in federal, state, and tribal court. You can't sue a state in federal court unless the tribe has waived sovereign immunity or Congress has passed a law that waived their sovereign immunity. So I'm going to real quickly talk about two very recent cases at the Supreme Court. The first was who can the tribe sue, or who can the tribe exercise jurisdiction over? Quickly, the facts of this case, Dollar General store leased a piece of tribal trust property from the Mississippi Choctaw in Mississippi. It was within the reservation. They signed a lease. They built a Dollar General store there, and they entered an agreement with the tribe. The local manager entered an agreement with the tribe where they were going to place tribal youth in this store to work. The kid was going to work for free in exchange for job training. The child alleged that the manager molested him, and the child's family filed a tort claim in tribal court against Dollar General and against the store manager. They eventually, the tribal court actually dismissed the claim against the store manager, finding that they didn't have personal jurisdiction over him, but they did find that they had jurisdiction over Dollar General. And this case was appealed to the Fifth Circuit, and the Fifth Circuit said, yes, the tribe does have jurisdiction over Dollar General. The Fifth Circuit held that Dollar General had explicitly consented to tribal court jurisdiction by entering a consensual commercial relationship in that they traded the labor of the child for his job experience. Something also that was very important, it was in dicta and it wasn't the basis of the court's decision, but it was very important that the lease from the tribe, where Dollar General leased this piece of property from the tribe, for the purpose of the lease, Dollar General explicitly agreed to tribal court as the venue and Mississippi Choctaw as the governing law to determine the lease. And so one of the kind of core tenets when courts are deciding issues of tribal sovereign immunity tend to spin on fairness. Is it fair to bring non-Indians into tribal court? Is it fair if we don't let people sue tribes? In this case, I think this kind of weighed in the fairness argument against Dollar General, saying you can't say you didn't know about the courts or you didn't know about their law, because in this kind of related lease, you explicitly agreed to go to tribal court and be bound by tribal law. So you can't come in here now and say it's not fair that you didn't know what you were getting into. So this case was appealed and accepted for cert by the United States Supreme Court. And because Justice Scalia was deceased and no longer on the court, we had a 4-4 decision. Because the Fifth Circuit decision was in favor of the tribe, it was simply affirmed by a 4-4 split. A couple of important things about this. This was the first time that a federal court of appeals had found that a tribe had jurisdiction over a non-Indian. There are a long line of cases about whether or not a tribe has jurisdiction over non-Indians. And in all of those cases, they talk about how theoretically they do if X, Y, and Z are met. But the end result of every one of those cases were no tribal jurisdiction. So this was an important case because it was the first time that they actually sided with a tribe and said, yes, in fact, you do have jurisdiction over this company. going to say something else about that, but I don't remember. I'm running out of time anyway. So the next case is kind of the opposite of this. So that was, who can the tribe sue? Who can the tribe exercise jurisdiction over? This case, it was just recently argued before the Supreme Court, was who can sue the tribe? So again, it goes back to this basic tenet that absent a waiver of sovereign immunity explicitly by the tribe or explicitly by congressional action, you can't sue the tribe. But this is one that has, I mean, it's kind of out there on the edge of the facts. So the facts are, Mohegan Tribe operates a large casino in Connecticut, and a Mohegan tribal employee who was a limo driver was driving patrons of the casino home. They come, they spend a lot of money, so you drive them home in a casino and drop them off. He's approximately 70 miles from the reservation, and he negligently causes an accident, car accident, state highway. A husband and wife couple who were injured in that accident sue him under tort law in Connecticut State Court, and they initially named the tribe as a defendant, but they dismiss them voluntarily because they know that the tribe's going to get dismissed on sovereign immunity grounds. They name this employee in his individual capacity only. The tribe comes into the case and defends him and says, nope, sorry, you can't sue him. He's an employee of the tribe. He was exercising tribal duties, and he is protected by the tribal sovereign immunity. And surprisingly, the Connecticut Supreme Court says, you're right, and they dismiss the case on sovereign immunity grounds. Now, the plaintiffs in this case appeal to the U.S. Supreme Court, and they accept the case. And everyone who practices Indian law is just cringing because the facts are so bad in this case. And but when you get into the arguments, it's not so clear cut. So someone else who was also injured in this argument filed a claim in the Mohegan tribal court, and allegedly were issued a judgment of $700,000 for their injury. The Mohegan tribal court explicitly exists for tort claims related to the casino because the tribal state gaming compact says it has to. So just a quick gaming, we're not even talking about this. Gaming 101, tribes can do Class 2 gaming on Indian land. If they want to offer Class 3 gaming, they have to enter into a compact with the state, and there are all these specific requirements that the compact has to have. And one of them is you have to allow tort claims against your tribe for gaming disputes, for prize disputes and tort disputes. And so one of the fairness arguments in this case was, we're not saying you can't sue the tribe, you've just got to go to tribal court and sue the tribe. But this is one we will get an opinion this year on, and it'll be a big deal because it's a Supreme Court case on sovereign immunity, and these cases are never limited to the facts of the case. Unfortunately, they have far-reaching effect for tribes, so this is one that we're watching. And that's my time. Thank you very much.